state have additional witnesses? No?
No, Your Honor, the state rests. The state's going to rest.
Okay, we'll bring the jury in. You can rest, and then we'll excuse the jury again. You can be seated.
He gets
All of
hit
the jurors
again.
You'll note that you don't have your transcripts of the interview that was played for you yesterday. We did pick those up, as I stated, pursuant to the agreement between the parties. You can have those back during your deliberations, okay? Just wanted to let you know that. Mr. Lavoie?
State rests, Your Honor.
Okay. Given that, your time here at this moment has been very short. We do need to ask you to leave the courtroom again. We have to deal with some legal questions, and we'll have you back as soon as we can. Thank you. All rise. Thank you. Can be seated. Mr. Dunham?
Yes. With respect to the charge of second-degree murder, Your Honor, the defense moves for judgment of acquittal on all elements, and I'm going to focus on element 3 as the court set forth at page 7 and 8 of the court's instructions, the unlawful killing. Element 4, the purposely caused or acted with the purpose, the conscious object to cause great bodily harm, and element number 5, the absence of extenuating circumstance such as sudden passion, great provocation, or mental condition.
Do you want to make an argument about that? You just feel that there's no evidence, correct?
Insufficient evidence of those elements.
Okay.
Your Honor, the defendant shot Ms. Alger 7 times. He emptied his gun. When the gun was empty, he reloaded it. Every trigger pull was a purposeful act. The firearms expert in this case, Harry Jeppe, testified that in order to fire that gun, you had to pull the trigger each time. That means that the defendant pulled that trigger 11 times. So any claim on his part that he didn't know or understand that what he was doing, that it was some sort of mistake done in some sort of haze, is belied by the proof. When you look at his actions through the day, he was behaving in a way that was normal for him. He was able to drive himself from Swanton into St. Albans to have a rendezvous with his girlfriend and to have an argument with his wife. Although he claims suicidal ideation, he did not make an attempt at suicide when this incident occurred with Ms. Alger. His focus was on her. The evidence showed that he continued to shoot her even as she was falling. The evidence of his intent is sufficient when taken in the light most favorable to the state, as the court must do at this stage, to prove the requisite intent. In terms of the absence of provocation, it's the state's contention that that issue will never be presented to the jury because there is simply no evidence of substantial provocation in this case. It cannot be the law that someone who's yelling at somebody, the crime of shooting them multiple times can be diminished in some way because of that simple act. It has long been the law that mere words are never enough to justify a physical attack.
The defendant has moved for a judgment of acquittal pursuant to Vermont Rule of Criminal Procedure 29A. Reviewing a Rule 29 motion, the court considers whether the evidence, when viewed in the light most favorable to the state and excluding any modifying evidence, fairly and reasonably tends to convince a reasonable trier of fact that the defendant is guilty beyond a reasonable doubt. A judgment of acquittal is proper only if the prosecution has failed to put forth any evidence to substantiate a jury verdict. Here, the defendant is charged with 3 offenses. The first is reckless endangerment, the second is murder in the second degree, and the third is negligent operation of a motor vehicle on a public highway. Although the defendant has challenged only select elements regarding the state's case, the court is going to review all charges. Regarding reckless endangerment, the elements of reckless endangerment are, first, that Matthew Webster is the person who committed the alleged acts. Second, that Mr. Webster placed Mr. Daly in danger of death or serious bodily injury. Third, that Mr. Webster did so recklessly. Regarding murder in the second degree, the elements of murder in the second degree are that Matthew Webster is the person who committed the alleged acts, that Mr. Webster caused the death of Ms. Alger, that the killing was unlawful. Also, that in causing the death of Ms. Alger, Mr. Webster did act with an intent to do great bodily harm. That when Mr. Webster caused Ms. Alger's death, Mr. Webster's mental state was not influenced by extenuating circumstances such as sudden passion or provocation that would have caused a reasonable person to lose self-control. Regarding negligent operation of a motor vehicle on a public highway, the elements of negligent operation of a motor vehicle are that Matthew Webster is the person who committed the alleged acts, that Mr. Webster operated a motor vehicle, that the operation occurred on a public highway, and that Mr. Webster operated his motor vehicle in a negligent manner. Regarding reckless endangerment, whether Matthew Webster was the person who committed the alleged acts. On September 25, 2013, the evidence reveals that the defendant was positively identified as the individual on that date who pointed a gun at the passenger of Ms. Alger's car, Mr. Daly. That Mr. Webster placed Mr. Daly in danger of death or serious bodily injury. The evidence reveals that the defendant pointed a gun at Mr. Daly and pulled the trigger, which placed him in fear of death or serious bodily injury. That Mr. Webster did so recklessly. In pulling the trigger of a loaded gun and pointing it at Mr. Daly, defendant acted recklessly in that he acted without regard to the possible consequences of his actions, ignoring a known, substantial, and unjustifiable risk that his conduct would place Mr. Daly in danger of death or serious bodily injury, and that in light of the nature and circumstances known to him that the gun was loaded, was a gross deviation from how a law-abiding person would have acted in the same situation. Regarding murder in the second degree, that Matthew Webster is the person who committed the alleged acts. The evidence fairly and reasonably tends to show that on September 25, 2013, that defendant was identified by several witnesses as the individual who drove and exited a black Subaru and confronted Ms. Alger. That Mr. Webster caused the death of Ms. Alger. The testimony of the medical examiner established that the bullet wounds Ms. Alger sustained were the cause of her death. That the killing was unlawful. With regards to the element that the killing was unlawful, the state must prove that the killing did not occur in self-defense, in defense of another, or in trying to stop another person attempting to commit a felony with force of violence. The killing is justified by self-defense if 1, a defendant reasonably believed that he was in imminent danger of being killed or of suffering great bodily harm, and 2, the use of deadly force was reasonably necessary to repel the perceived threat. Vermont law provides that a person who kills or wounds another in the just and necessary defense of his own life shall be guiltless. Defendant's belief that he faces imminent peril and his belief that he must use deadly force to protect himself from that peril must be reasonable. The defendant's belief of imminent peril is not in itself sufficient to invoke self-defense. Rather, the belief must be grounded in reason. Although it is an affirmative defense, in the state's case in chief, there were no facts elicited which would support a defense of self-defense. The testimony establishes that defendant believed that Ms. Alger was charging him like a 6-point buck, that defendant was generally scared, that the victim approached defendant pointedly and purposefully and used an expletive when she spoke to him, that he believed the passenger was going to take care of him, and at one point defendant believed two people were coming at him. Yet none of these facts establishes that defendant reasonably believed that he was in imminent danger of being killed or suffering great bodily harm. No threats were uttered. Neither the passenger in the victim's car nor the victim had any weapon or made any physical gesture which was indicative of any intention to commit harm. Ms. Alger pointed her finger at defendant as she approached him, but nothing more. The time period from the point when the car stopped until defendant began to shoot, their entire encounter was brief. A belief that defendant was in peril is not grounded in reason based upon the circumstances which confronted him. The next essential element of murder in the second degree requires that in causing the death of Ms. Alger, Mr. Webster act with an intent to do great bodily harm. The court finds that in shooting Ms. Alger, the defendant not only intended to stop her, but that he intended to stop her with a conscious awareness that he was holding a loaded weapon and intended to use that weapon to stop her by causing great bodily harm. Moments before turning the gun on Ms. Alger, defendant attempted to commit suicide but could not bring himself to do so, evidence of a consciousness that he was holding a gun and of its lethal potential. He held the gun as he exited the car, and in his own statement to the police indicated that he attempted to holster the gun, further evidence of his knowledge and awareness that he still held a dangerous weapon, and nevertheless, in his desire to stop the victim from advancing on him, he used the weapon to shoot her. Mr. Webster is familiar with guns and their destructive capability, and knew in firing the weapon that it would stop the victim's advance, an intention to cause great bodily harm. That when Mr. Webster caused Ms. Alger's death, Mr. Webster's mental state was not influenced by extenuating circumstances, such as sudden passion or provocation that would have caused a reasonable person to lose self-control. With regards to the last element, the state must have proven that Mr. Webster's mental state was not influenced by extenuating circumstances that would have caused a reasonable person to lose self-control. It is black-letter law that sudden passion or provocation that would cause a reasonable person to lose control is an extenuating circumstance. The Vermont Supreme Court has not specifically defined provocation. Yet in order for provocation to be established, the facts must show that the provocation was adequate, that there was inadequate time to regain self-control or cool off, that there was actual provocation, and that there was actual failure to cool off. Here the court finds that the state has introduced evidence that fairly and reasonably tends to show that Mr. Webster's mental state was not influenced by extenuating circumstances such as sudden passion, or provocation that would cause a reasonable person to lose self-control. Although the evidence reveals that Mr. Webster had recently engaged in emotional conversations with both his wife and Ms. Yandow and ran a red light prior to his encounter with the victim, Ms. Alger, he nevertheless maintained an awareness of the circumstances and his surroundings. He engaged in a deliberative process, weighing whether he would in fact take his own life. His wife informed him that he had run the red light, and he engaged in a thought process which led him to take a precaution. He pulled over to the side of the road. When confronted by Ms. Alger, as noted, he initially attempted to holster his gun, could not, and formed an intent to stop her advance by means available to him, the gun in his hand. Neither passion nor provocation here was adequate. Neither the emotional discussions between defendant and his wife, and that with Ms. Yandow, nor the encounter with Ms. Alger, nor a combination of the two amount to adequate provocation. Although these encounters each had an emotional impact upon defendant, neither of them, nor all combined, would cause a reasonable person to lose self-control. The state has met its burden to show that the defendant was not provoked because the situation between himself, Ms. Yandow, and his wife was one of long duration, existing over several months, and variously of greater or lesser intensity over that period of time. Although his wife had removed her engagement and wedding rings, there was an agreement between her and the defendant to continue their discussion with each other at home. And that was where defendant was headed prior to his encounter with Ms. Alger. those circumstances do not amount to adequate provocation. The encounter with Ms. Alger, a disagreement between drivers, even anger with Ms. Alger leaving her car and shouting an expletive at the defendant, pointing at him and approaching him, also does not amount to adequate provocation. It is not reasonable under those circumstances to lose control and to resort to the physical violence to which the defendant succumbed here. There was adequate time to regain self-control. Defendant had time during his travel from meeting with Ms. Yandow and his wife to cool off. He was reflective during that time, and while upset, had the presence of mind to consider whether he would kill himself and determined he wanted to live. When he ran the stoplight, he was able to reflect upon that and make a conscious decision to pull over, which the court also finds is a conscious decision to regain his composure. There was no actual provocation. Just as there was no legal provocation, there was no actual provocation here. Defendant made a conscious decision to shoot Ms. Alger and did not shoot her because of passion or provocation. Whether Mr. Webster actually failed to cool off, this element assumes that defendant acted out of passion or provocation, which the court has not found and is therefore inapplicable. Regarding negligent operation of a motor vehicle, that Matthew Webster was the person who committed the alleged act. Defendant has been positively identified as the person who drove through a red light. That Mr. Webster operated a motor vehicle. The evidence shows that defendant operated a motor vehicle, a black Subaru. That the operation occurred on a public highway. The street where the alleged acts occurred is a public highway in St. Albans, Vermont. That Mr. Webster operated his vehicle in a negligent manner. Negligence is failure to exercise ordinary care. The care that a prudent or careful person would exercise under the same or similar circumstances. The state's evidence shows that defendant drove his vehicle through a red light at an intersection on Main Street in St. Albans. Running a red light is a violation of a traffic safety law, 23 VSA, section 1021A. Because a prudent person exercising ordinary care would not run a red light under the same or similar circumstances, defendant was operating his vehicle in a negligent manner. The state's evidence fairly and reasonably tends to convince a reasonable trier of fact that defendant is guilty beyond a reasonable doubt of negligent operation of a motor vehicle on a public highway as well as the other offenses. Therefore, defendant's motion for a judgment of acquittal is denied.
Your Honor, two small points. One is that the individual who's the subject of the reckless endangerment, his last name is Daly and not Daly. The other point is that the defendant's vehicle was identified as a black Ford Escort. His wife's vehicle was an orange Subaru.
Okay, the court modifies its decision and adopts those facts. Is there anything else?
No, Your Honor.
No? Mr. Dunham, does Mr. Webster intend to present a defense?
We do, Your Honor, and I believe our first item is we were in the process of getting this set up. We didn't want to totally set up until we were sure the state was going to rest. So we get that set up, we'll be ready to go.
How much time do you think you need? 10 minutes?
Well, I'll hopefully less than 10 minutes, but we'll keep Bob posted.
Okay, so we'll try to come back in about 10. Okay? Thank you. Thank you. You can be seated. Mr. Dunham? Or Mr. Cadams, I should say.
Thank you, Judge. We call Kyle Gagne. Good morning. Say your name and spell your last name.
Yep, Kyle Gagne, G.
How old are you?
23.
And where do you live?
I live in Swan, Vermont.
Do you work?
I do.
What do you do for work?
I work full-time for a contracted company for the New England Central Railroad and part-time for Swan Village Police Department.
You need to keep your voice up
Okay.
as you're testifying. Do you remember September 25th, 2013?
Yes, I do.
And we're at about 5:30 in the afternoon. Where were you on September 25th, 2013?
I was southbound on Route 7 or Main Street between Domino's and the Fitness Zone.
And did your attention get called to anything?
Yes, there was, I had my windows down. I could hear a male out to the left of my vehicle. He was sitting on the ground and he was crying and screaming.
What was the flow of traffic like at that point?
It was complete standstill. Traffic was stopped on both sides of the road.
And so you're heading south on Route 7, and you have your windows up or down?
I had my windows down. Both front windows were down.
And can you describe where your attention was drawn to this gentleman? Can you describe where he was?
Yep, he was directly to my left, straight to my left, on the opposite side of the road, maybe 5-10 feet up into a driveway, sitting down.
And was he with anyone?
Yes, there was a female that was holding him on the ground. She was down on the ground as well.
And could you hear the words that he was saying?
Yeah, I could hear him say he was...
Objection, Your Honor.
Nature of the objection?
Well, right now, that wouldn't be responsive. The question was, could you hear what he was saying? That's a yes or no. And then I'll have a subsequent objection, assuming that he's trying to elicit the content.
Okay, sustained.
Could you hear the words that he was saying?
Yes.
And what were those words?
Objection, Your Honor.
Nature of the objection?
It's the defendant attempting to elicit his own statement.
Mr. Tatum?
They're not offered for the truth, Judge, so they're not hearsay. It's just the words that he said. It's not offered for the truth of the matter. And in fact, the state has has already put those words in, so for completeness sake, if they were to be different, but I think it's actually pretty fairly consistent with what the state has already put in of words of the defendant.
All out.
So what did you hear the gentleman say?
I could hear him say that he was trying to make it work and that he didn't mean to hurt her and that he loved her.
And what was the demeanor of this person, the gentleman?
He was just crying, sobbing.
And so then what did you see after that?
After that, a male approached from the north heading southbound, walking in the opposite lane. And the male that was on the ground looked out at him and said, "Don't come any closer, I don't know who you are." So the male kind of like put his hands up and he's like, "I'm not going to come any closer, I just need to know where the gun is." And then at that point, that's when the officers came from the north heading south. And they got out of their vehicle. That's when I started to pull my phone out of my pocket. And I could see the male that was sitting on the ground reached into his lap and grabbed the gun out of his lap and set it down to his right. And then he stood up and pulled some items out of his pocket and set them down on the ground next to it. And then stood up and took a couple steps away from it and then laid down onto his stomach with his arms out. And that's when I hit record on my phone.
And so you took out your phone and started recording a video?
Yes, sir.
And did I show you what's been marked as a portion of what video on a disc of Defendants F for identification prior to you coming into court today?
Yes, sir.
And what is that video?
It's the video that I took on my cell phone.
All right, move for the admission of Defendants F.
I'm not sure that was part of the stipulation. Is there any objection to F?
No.
No? So F.
I'm sorry, Your Honor. No objection, Your Honor.
Okay, so F is admitted without objection.
I'd like to actually admit a portion that we played to the jury.
Any objection?
Well, if we could approach, Your Honor.
Again, you can have a conversation with your neighbor. Please don't talk about the case. Thank you.
So with the court's permission,
Yes, that's
play
fine.
approximately the first minute or so. Yes. what's the timestamp on there, Morris?
1 minute, 21 seconds.
We move for the admission of the first minute and 21 seconds of that defendant's F.
Any objection?
I thought, I'm sorry, I thought it was already offered in a
It
minute.
was.
No objection, Your Honor.
So
I don't-
that
So far, I
portion
got no
alone
question.
That portion alone.
of the whole exhibit.
Yes. No further questions.
No questions, Your Honor.
No? Okay, thank you, sir. You are excused.
Thank you.
We have another witness then.
To Judge Marie Boudreau.
So far.
Can we move this just a little?
Good morning.
Morning.
State your name for the record and spell your first and last name.
Marie Boudreau, M-A-R-I-E-B-O-U-D-R-E-A-U,
Okay, and where do you live, Ms. Boudreau?
St. Albans, 6 Beverly Court.
And do you remember September 25th, 2013?
Yes.
Did something come to your attention around 5:30 or so on, where were you at 5:30 or so on?
I had left my house to go to Joanne's Fabric, so I headed across Main Street.
And which way were you traveling on Main Street, north or
North.
south? And did something, did your attention get called to anything as you were driving north on Main Street?
Yeah, as I was approaching the fitness zone, I saw 2 cars on the right-hand side of the road. And I wasn't really paying attention, but there was 2 people standing outside in between 2 cars. And then what caught my attention was I heard what I thought was firecrackers.
Were you doing anything other than driving at the time?
Yes, I was talking on the phone.
Back when it was legal to talk on your cell phone
Exactly,
when you were
yes,
driving?
yes.
All right. And so you were talking on the phone, and you heard something. You saw the 2 cars driving on the parked on the side of the road,
Right.
and then you heard something. What
Yes,
did
I
you
was
hear?
slowing down, and then I heard what I thought was firecrackers. And then I saw the person fall on the ground, and then I realized it was a gunshots, because shortly afterwards, the gentleman put the gun to his head.
And did you see the gentleman with the gun prior to him putting it to his head?
With the gun? No,
Yes.
I didn't see the gun until he put it to his head.
And how soon after the firecrackers did you see the gun go to the person's head?
Almost immediately after.
And did you hear, where were you at that moment?
I was probably 1 or 2 cars within the last car, and I was inside my car.
So you were heading north, and you were 1 or 2 cars from the last car that had been parked on the side of the road?
Right.
And so then, what happened?
And then I was in my car, and I was trying, I was talking to my niece. I said, oh my gosh, she's been shot. So I was going to try to call 911, and then another gentleman came up to my car and said, oh my gosh,
Objection, Your Honor.
Nature of the objection?
It's not responsive to his question, and she's speaking about what another person had said.
Mr. Kadam?
Well, I'm not sure what the statement is that she's alluding to, so.
Is it to what the other person said as they approached?
Yes, Your Honor.
Okay.
This other person that, if I may, Judge, this other person that approached, did they talk about what they saw or what they didn't see?
They said that they had gotten cut off.
Okay, then you're going to, again, I need to, may we approach, Judge?
Can I come?
This individual that came up and spoke to you, did you see where that individual came from?
He came in the vicinity of the cars. I'm not sure. He just came towards me by the cars.
And is this a male, female?
It was a male.
You just do you remember what he looked like any more than that?
No, he was a male.
And then what did this person have to say to you?
He,
Objection.
I'm going to allow. Go ahead.
You can answer.
sorry. He came towards me and he was, he wanted me to call 911. And he said to help me or whatever. And I was trying to call 911 at that time. And he did mention about being cut off.
Did he say anything else?
Not that I can recall, I don't.
Do you remember giving a statement to the police that evening, later on, 10 or 11 o'clock in the evening? The police came to your home?
Yes.
And you gave them a statement?
Yes.
And if you were to review that statement, might that refresh your recollection of other things that this person said?
Yep.
Do you have a page reference, Bob?
I got it.
Page 6.
Thank you.
Showing you what's been marked for identification. Take a look at that and tell me if you can recognize that document.
Yes.
And what is that?
That's my statement.
Okay, you've had a chance to review that?
Yes. Yeah.
If I could call your attention to page 6, line 18. If you could read line 18 through 20 to yourself. And then,
18 to 20?
Yeah,
Okay.
just read it to yourself. And then,
Yes.
does that refresh your recollection as to what the gentleman said to you?
Yep.
What did he say to you?
He got out of his car and started arguing, and he pulled the gun. Do you want me to read the whole thing?
Well, did you say to the police that he cut us off, and then he got out of his car and we started arguing? He pulled the gun. Is that what the gentleman said to you?
Yep. If that's what I said, I don't, it's been a long time. I said it.
That the gentleman said to you, we started arguing, correct?
I believe that's what I said, yeah.
Well, that's what you told the
That's
police.
what I told the policeman, yes.
The night of the incident.
Yes.
I don't have anything else.
Any cross-examination?
Just a moment, Your Honor. Lisa?
I want the day.
17, 14. That's fine.
Yeah, that's the one you want to impeach over
I
right there.
just started.
Yeah.
Do you recall giving a deposition in this case?
Yes.
And do you recall being asked about what this gentleman that you just spoke about had said to you?
Yes.
And do you recall saying that, I don't really remember saying that we started arguing? I don't know if it was that we or they or we, maybe it was, I really don't remember, I don't recall.
Right. At the deposition, it was months later, and I don't remember exactly what was said.
That's all I have.
Was there any follow-up?
Just, the deposition was in March of 2014, correct?
Yes,
And the statement you gave to the police about what the gentleman said was the night of September 25th,
Right.
correct?
that's right.
So it would have been fresher in your mind on September 25th, 2013, correct?
Yes.
Nothing else.
And on that, Ms. Brochu? any-
Nothing.
No? Okay, thank you, ma'am.
Thanks.
Gary Ricks.
Only because we left it alone. I mean, we should have left it alone. That was my fault. I told you that. So don't worry about it. Oh, Jesus Christ. You want me to do Rex?
Yeah.
Give me a smile.
No.
Okay, good. It's all good for us because the self-defense is bullshit. Yeah, yeah, yeah.
Could you tell us your name?
Gary Ricks.
And where do you live?
I live at 5 Edward Street.
And what do you do for work?
I work construction.
So, do you remember the early evening or late afternoon of September 25th, 2013?
Yes, I do.
Do you recall what you were doing?
I was going to get my kid's mother from work at Price Chopper.
And did you, in fact, well, who specifically were you going to get?
Erica Therian?
And did you pick her up?
Yes.
Okay. So then what happened?
We were just driving on our way back home
Going
towards the incident,
towards the city?
towards the city, yeah.
So you're going from north of town to the north, and now going south?
Yes.
And what happened when you got in the area of Domino's and the fitness zone?
We saw two cars pull up, one first and then the other behind it. And the lady in the second car got out, and then the person in the first car got out, and they were just headed towards each other.
Okay. And where were you at that point?
Really directly side by side.
Okay. And where were you within the car?
I was driving.
So you were the closest?
Yeah.
Okay, so you went, when you were side by side, what did you see and hear?
I couldn't really hear anything, but I could see the second car. The lady got out, and it looked like she was saying something and talking with her hands. I mean, you could tell she was upset about something.
Okay, can you show the jury exactly what she was doing with her hands?
Just talking with them, I guess, just waving them up in the air.
So the record should reflect that the witness raised both his hands above his head in the air and waved them back and forth. Go ahead.
So, could you tell her state, whether she was happy or sad?
She didn't look happy.
Can you describe what her appearance was in terms of that?
Looked like she was upset about something.
And was she making noise?
I couldn't tell. It looked like, yeah, she was saying something.
And the gentleman?
No, I didn't notice.
At first?
No, I didn't notice him saying or doing anything. Just get out of the car and start walking towards her.
So he seemed calm?
For the most part, yeah.
And then what happened next?
We got past them and I heard the shots.
How far did the woman advance from
From her car?
compared to her driver's door?
Not far at all. Last I could see, it was maybe 5 feet in front of her car.
Did you know that woman?
No.
And so you had a couple kids?
Yes.
Yeah. So what did you do when you heard the shots?
I slowed down, and because of the kids, I pulled farther down the road and just pulled over and called 911.
When they were walking towards each other, was one more aggressive than the other?
Objection. Leading, Your Honor.
No, I'll allow it.
Maybe I wouldn't say aggressive, but she was out there talking like with her hands. No, I wouldn't say aggressive, but I don't know, she just looked upset. She was talking or yelling something and just talking with her hands, I guess.
Could you tell that she was yelling something?
I could tell she was yelling something, yes. I couldn't tell what it was.
Could you tell whether or not she was upset?
Objection. Asked and answered.
Sustained.
A moment, please.
That's not going to get any better than it is right now.
So when you gave your deposition and description of the hands, you called that, you referred to it as flailing, is that correct?
Yeah.
You could tell him, you can lead him, so you can say, so whatever you meant by flailing is what you already showed us.
That's all I have, Your Honor.
Just, was there anything else?
One question. So when you use the word flailing, that's what you already showed us with her hands up by her head, just talking
Right.
with her hands?
Just, yeah, kind of talking with your hands, I guess, just having them up in the air.
Just have your hands up in the air by your head?
Right.
Okay. That's all I have.
Anything else?
No, Your Honor.
Your excuse, sir. Thank you.
Thank you.
Mr. Dunn?
We approach.
Again, hand stretched out to your neighbor. Okay, thank you, folks. So we're going to take another break. I hope this one is in the neighborhood of about 10 minutes and not more. Are the parties ready to proceed? We're back on the record then. Ms. Brochu, Mr. Leroy, Mr. Dunham, Mr. Kadams, Mr. Webster, Ms. Trapas, and Mr. Malone are present in the courtroom. The jury is not present. The court examined Ms. Wood in the jury room and thereafter spoke with the attorneys. As a result of that, how do the parties want to proceed? Mr. Leroy, Mr. Dunham?
By agreement, the parties are going to submit portions of the deposition of Rosewood, which was taken on June 18, 2015 at the Franklin County State's Attorney's Office. And the parties have agreed on the portions of the deposition that would be received by the jury. It's the parties' desire that the jury have that exhibit today for their review and be able to review it together in the jury room.
Or make them copies and let them read them and hand them back. Probably that. And it would be an exhibit. It wouldn't have any special treatment. It would just be a simple exhibit later on. Together with the other exhibits, they wouldn't have the copies later on.
Do you want them to read it in the jury room, or do you want them to review it in the jury box?
I prefer they just read it individually. That way there won't be any temptation to talk about it while they're reading it.
You mean here in the courtroom?
Yeah, we just give it to them and give them the time to read it.
That's fine, Your Honor.
Okay. And the court let them go at about 12:30 because by 12:15 or so, the court was still determining how we were going to proceed. I told them that I did anticipate further discussion with the lawyers at 1 o'clock, understanding that they were leaving for lunch late and that I knew that we would be talking on the record without them being present. I told them they could come back at 12:15. So have the parties made the copies of those portions of the deposition that they want to submit to the jury yet?
I have to finish the redaction, Your Honor, and I didn't want to make redacted until, but I'll do that. John and I can work on that right now.
Okay,
Mr.
so
Webster has just read it, so he needed to get his approval, so.
Okay, so there's still some time for you to work on that before the jury comes back, and then I need to be assured that the arguments that the parties raise regarding possible other accommodations to allow for this witness's testimony are not still arguments that the parties are making, that this agreement to proceed in this manner resolves the concerns, the arguments and objections of both sides. Mr. LaVoy?
That is true from the state's point of view, Your Honor.
Mr. Dunham?
Yes.
All right then. So we'll give you some time to redact those portions of the deposition that you do not want the jury to read. Was there something else then? Mr. LaVoy?
Well, no, nothing we need to take up here, Your Honor.
And was there anything from the defense then?
No, I want to finish the jury business.
Okay, so I anticipate them to be back in the building within the next 5 minutes. As soon as they're back and the deposition has been redacted, we'll have them come back in. Are you going to have other witnesses today, Mr. Dunham?
No.
Okay. So the plan then will be to have them come back in, and then the court will instruct them that there is an additional exhibit the parties have agreed should be admitted for their review, and it is a portion of a deposition of Ms. Rosewood.
Oh, yeah, we probably should check with the one juror who watched the news.
Do you want to inquire of her before we break for the day?
Yeah, just have her, if she would stay for a few minutes, and then the other jurors can start their...
You're okay with excusing the other jurors?
Yes.
Okay. Do you agree with that, Mr. LaVoy?
And I never did it.
After they do this business, correct, Your Honor?
Yes.
Yes.
Okay.
And I'm sorry. I was referring to the deposition when I said this business.
Okay. So we'll give you a few more minutes. When you're finished with that, Mr. Dunham, make sure that we get copies of it so that we can make copies for you.
All right.
So we're back on the record then. The court has what has been marked as Defendants Exhibit G. It's deposition of Rosewood, June 18, 2015. Is this the redacted copy of the deposition that the parties agree should be submitted to the?
That's a copy, but I'm told there was a G. By others, I'd asked.
No, oh, so it should not be G?
I'll put an H on this one. We're gonna take this right back.
You're going to take them right back? I thought they were going into the jury room.
The one that's going to go in the jury room is going to be marked H.
Okay, so you want them to review these, return these, and then they'll take what is now being marked H, the single copy, with them into deliberation?
It'll become part of the collection of exhibits.
Okay, so let's bring in the jury. So Bob, I'm going to give these to you to pass out. And you can put,
What?
what are you looking for?
This. You need to turn it off.
Yep, that's a good idea.
My daughter's been calling me all day. I spoke with Lois last night.
Yeah.
Can the court ask the jurors not to watch national news either?
Is there any objection to that?
No,
Okay, that's
guilty. Yeah. And then there was, the other incident was in Chattanooga. You heard about that?
Oh, that's not the one with the, no, we
We
haven't
only
did
have
that.
a few minutes to actually.
Head sounding guy killed 4 Marines.
Oh, yeah, I didn't know that. I did that.
all right.
You know, I am so fucking racist. I want you to know that. I
You don't
don't
mean that.
actually. Okay, good. My African American. Or at least I was not. It was 15 years ago. Christ. So old. Just saying.
Okay, thank you. The record should reflect that all of the jurors are present. At this point, each of you is going to be handed a copy of a deposition of a witness, a Miss Rose Wood. I'm going to ask each of you to read that at this point, and when you're done reading it, just indicate to us, and we're going to take your copy back. You will have a single copy of this deposition available to you in the jury room during your deliberations. Mr. Dennis?
Can I formally offer the exhibit?
Yes.
The deposition testimony of Rosewood, which the actual exhibit is marked H, so you.
Stop smiling, Steve.
You're not a board at this point, but the actual exhibit is marked H.
Okay. Any objection then, Mr. LeBoy?
No.
Okay, so H is admitted without objection. And you folks can read that now. Does anyone still have a transcript? No? All right then. Do you have another witness today, Mr. Dunham?
No, Your Honor.
Okay. So we're going to recess for the day then, and we'll have you folks back here on Monday morning at 8:30. I will instruct you not to discuss the case with anyone. That means each other, family members, or anyone at all. Do not read or listen to any account of the case in any form, in the newspaper, on TV, online, listening to the radio. Also, I'm going to instruct you not to watch the national news. So that may be a hardship for some whose regular practice it is to watch the news every night, but I'm going to ask you not to do that for the next couple of days. And I might give you the same instruction again on Monday, okay?
Your Honor, that would be to read about it, so.
Or to read about it, okay? So do not access any national news between now and Monday morning. Also, as I indicated to you yesterday, do not go to any place that has been described in the testimony so far. Most pointedly, the alleged scene of the incident in this case. Okay? All right then, so you can leave your notebooks on your chair. We will collect those and keep those secure for you. And we'll see you at 8:30 on Monday morning. All right?